Okay, Diane, we are ready to go.
All right, so we are on the record, correct? We have a court reporter.
Yes, I'm ready.
Thank you. We are here for an inquiry concerning a magistrate judge, Marty K. Clark, docket number 2265 for judicial conduct. I'm Diane Sorensen. I'm the chair of panel B, who is the hearing panel for this matter. Could I have everyone who's appearing state their appearances? Correct. We have a court reporter.
Judge Larry Hendricks.
Thank you. We are here for an inquiry. Oh, get an echo.
I have it, a little feedback. I think Doug is working on.
Yeah. For judicial conduct. I'm Diane. I'm still hearing myself.
I'm sorry, Diane. Hold on 1 second.
Could I have everyone?
I think he put us on a 10-minute delay.
Oh, you're muted. We're good to go. Okay.
Yeah.
He probably has to mute himself so you don't hear the feedback in the room.
Got it. Okay. So yes, the other members of panel B who are here, why don't you identify yourselves?
Rosemary Colich.
And we have Alan Glendenning, he's muted.
Larry Hendricks.
All right. So those are our panel members who are here. We have a couple of more who couldn't be here today. And then for the judge.
Chris Joseph appearing by Zoom with Judge Clark, also by Zoom.
And Todd Thompson appearing as the examiner for the Commission on Judicial Conduct.
Okay, thank you. So what we're doing here today is having our pre-hearing conference. So we need to determine what discovery issues we have. We need to talk about if there are things that, or if there are stipulations, admissions, what the issues in controversy are. We need to set deadlines. And then finally, we need to determine a hearing date. We need to figure out how long the hearing will need to be. It has been suggested to me that rather than determining a hearing date at this pre-hearing conference today, we might end up needing to do a doodle scheduler. Maybe we could get a general time frame today and then do that, so that because we have busy hearing panel members who will need to weigh in on when they're available. All right. So let's start with the discovery issues.
Frankly, the discovery issues tie into an effort that I've begun with Mr. Thompson, which is to see if we can reach stipulations that just cover everything and submit on stipulation and arguments, given the fairly simple and narrow issues that are presented here. I submitted to Mr. Thompson a proposed set of stipulations. He has, we've had some communication. At this point, I don't know whether or not we're going to be presenting live witnesses or a joint set of stipulations. And to me, that's really the first hurdle to cross to see if we can agree on everything. Because frankly, if we can't, then we're going to have live witnesses anyway. I mean, the stipulations by and large become somewhat less important. And so I don't know, it was fairly recently that I gave Mr. Thompson our stipulations. So I don't know if he's had time or if we need more time to try to figure out whether or not we need live witnesses or not. But that's where we are from my standpoint.
Yeah, well, that is a big preliminary matter. If we can do it by stipulations and argument, that would save everybody a lot of time. Todd, what are your thoughts on that?
Well, I responded to their proposed stipulations, and they rejected a couple of my suggestions, and they also rejected or denied some things in the complaint. So we do have just a few issues of fact that are in dispute, but I think most of the allegations in the formal complaint have either been admitted to or underlying facts stipulated to. And a dilemma that I have in this particular case is that other than the judge and his wife, all of the witnesses are out of state. The friend, if you will, has moved to Illinois, and she has refused to give me her address. She's given me 2 counties in which she lives, but I don't actually know her address. And then the complainant lives in Columbia, Missouri. Frankly, I have no doubt he would be willing to appear in person because of his eagerness in pursuing this matter. But I do have the dilemma of witnesses being out of state. And if we were going to have their testimony, we would have to probably do it by taking their depositions in advance of a hearing. But most of the factual matters have been agreed to. We have 20-some stipulations that we've passed back and forth and agreed to.
And how significant are the ones that you've been unable to agree to so far?
If I could read the panel's mind, I could answer that question. I'm not
We don't
sure.
know our own mind yet.
I'm not sure how significant they are. And I'm certainly willing to try and refine them or narrow them so that they would become acceptable to both parties. One, I don't know that we're going to get agreement on, in that 2 of the people I interviewed had indicated respondent had sent photographs to the Lisa, and he is denying that and refusing to stipulate to that. And I do think that's probably a material issue.
So do we need to set a deadline for trying to work out whether all the facts can be stipulated to, and if not, then deposition testimony, a deadline for that?
I think that's fine.
I agree. I think that, yeah, we started this effort to draft and circulate, I think, a matter of 2 weeks ago. So, I mean, we haven't had a lot of time. And I don't think there's that many that we're far apart on. I mean, that whether or not, sending of images, whether or not that happened or not, is something that we could, I don't know on that one. That doesn't, Todd and I can be creative and perhaps figure something out on that. If not, yeah, I agree. Then if Todd wants to go have depositions, we can do that. We can't reach an agreement, then we go depose the folks and present that way.
So let's set a deadline for stipulation of facts to be completed. What do you think? 30 days from now? Less than that?
I think we can do it in the next 10 to 14 days. If we're not going to agree in the next 10 or 14 days, we're not going to agree.
Okay, so let's say 2 weeks from today. That would
The
be
only problem.
Christmas Eve.
The only problem with that, I was going to say that the 2 weeks from today really is only 1 week from today. So given that schedule, so I mean, I think 30 days might be a little bit easier if we go to January 10th, just to make sure that we are both in town and can knock this out and give a.
Okay, so what do you think about January 10th? Okay.
Sure.
All right, and then
I'm sorry, should we make it January 11th, which is a Monday?
Yes, please.
I should look at my calendar. All right, and then, okay, so if any deposition need is dependent on whether there are facts in controversy at that point, maybe we should have we should meet again to report where we are with that. If you're able to stipulate to all the material facts, I guess we could set a time then for argument on those. Other thoughts from members of panel B?
Well, why don't you have them get back with you, Diane, and say if they were able to take care of all the stipulations. If they were not, then you can set a date with them as for the discovery, because that's the next step, I think. So then
Right.
set a date. not too far out. We're going to be getting into next June if we do. So let's set, 30, 45 days. Chris, Todd, do you think that would be enough for discovery after you told her on the 10th, one way or the other?
I think so. And let me make this suggestion. I would probably suggest scheduling the depositions for some point after January 11th. They can easily be canceled, but we can go ahead and get the witnesses served and have those set if we need to go forward with them. And we'll have them on our calendars right away, so that, because calendaring is always a problem. So my suggestion is we book those depositions. If we can stipulate to the facts, then we just cancel them.
Okay. And then let's go ahead and you guys can set your depositions, but let's go ahead and set another deadline for the discovery to be completed, discovery if necessary. Maybe 30 days out from January 11th. Would that be doable? You're talking only about a couple of witnesses, it sounds like.
Yes, and I think if we schedule them to be late January or early February, then the middle of February for concluding discovery works fine.
How about February 12th? It's a Friday.
I'm fine with that. Todd, are you anticipating doing Zoom depositions as opposed to physically going out there? That would make it a lot more doable in 30 days.
That would be my preference.
Okay. Then that should be just fine.
Okay, so then after that, whether there is or isn't discovery, if you've stipulated to all the facts, great. If you've stipulated to the facts, what we need to schedule is a deadline for you to get your written arguments to us. And then I would assume you would want to do oral arguments. We would want oral arguments as well, so that we could ask questions, I think. We haven't done one of these. My panel has done 2 hearings, and we have had evidence at both of those. We had a summary judgment motion in one of them and didn't quite know how that fit into our process. This makes a lot more sense if you do stipulated facts and argue on those. But I think we would want to be able to ask each of you as counsel questions if we did it that way. So it would be great if we could get this to hearing or have those arguments by sometime in March or early April. So, Michelle?
I might throw out there, Diane, your next actual panel meeting is on March 5th.
March 5th.
If you wanted to, we could actually have your hearing or arguments or whatever on March 5th, and then we could conclude and do whatever we needed to do and kind of bump it in together. I don't know, Doug, what you think about that. That's really.
Set it for March 5th, either arguments or
The only concern is if we're submitting depositions, that's 3 weeks later.
right.
That's transcripts, turnaround. That's pretty tight for
I
putting it all
agree.
together.
That's probably pretty tight. And even for us, if you submit written arguments and all your stipulated facts to have reviewed and be ready by March 5th.
that's-
So maybe first part of April.
Sure.
So Michelle, you have your other panel A meets on first Friday in April, correct? So that would be out.
That's correct. That's correct.
I don't know. It's a little bit difficult until we know if you've stipulated to all the facts to know whether we're scheduling what we're scheduling. We're either going to be scheduling arguments and a deadline for any briefing, or we're going to be scheduling an actual evidentiary hearing. I guess we could use kind of the same tentative time frame. That we
And
want.
are you going to know how many, I mean, do you anticipate this is going to be done in a day? Are you going to need 2 days? Or, I mean,
We don't know because they don't know if they're able to stipulate to all the facts yet.
and you also don't have the rest of your panel here to know if this date is going to work. So if you want, I don't know how you would do it, Diane, but you may want to try to consider maybe some kind of a deadline or something to get your final submissions and material, and then we can do the doodle poll to try to do scheduling between the panel and the council to get a date certain for either arguments or, you know, if we're going forward on stipulations or if we're going forward on actual witness testimony. And that way we would have a better idea of how many days you need and actually get dates that are available for all parties.
Well, okay, I'll tell you what, it seems like we have the deadline for the, to determine stipulations of January 10th. I feel like we need to touch base after that to see, and I know we have the deadline for discovery and you can get your depositions scheduled. As Todd said, you can cancel those easily. But why don't we have another, kind of another pre-hearing conference after January 10th? That way we can know as a panel which approach we're taking, whether we're going to an evidentiary hearing or whether we're going to be deciding this on stipulated facts. Does that sound good?
Yes.
Okay, so on that, we could schedule that, don't you think, Michelle?
Absolutely. Yes.
Okay, so let's do that the week after January 10th sometime. Anybody have dates they're unavailable that week?
What about January 11th? Does everybody have their calendars right now?
I do, I'm open.
It's good with me, Diane.
I'm open.
Chris
Since
and
that-
Todd?
I have a hearing at 1:30 scheduled by Zoom, but otherwise open.
Does that going to take all afternoon, do you think, that hearing?
I would hope not. I think this is it's in federal court, and I think they're giving us individual specific dates to join, because it used to be we'd be on the afternoon docket and it would say 1:30. I'm reading my calendar to mean that I'm actually having the hearing start at 1:30 as opposed to be on the docket that, you know, goes to whoever knows when. So I believe that I would be done by 3 for sure, 2:30 or 3.
Or do you want it, since that's so close to the deadline, do you want to go into the following week? Like, I'm going to throw out just like the 21st of January. What's the 21st of January look like for council and for the panel?
I've got an all day
You have all day
hearing
on
in
that.
that.
Well,
Yeah.
I think it'd be better to have it closer to the 10th because that way we can start setting the other dates. If you push it back to the
Okay.
21st, now you're beginning to push all the rest of the other dates back. So
Okay.
How does the 12th look? Like first thing in the afternoon on the 12th? That's a Tuesday.
I'm open.
I can do it.
Okay, let's do
I can do it.
1:30 in the afternoon on the 12th. And that's to find out where we are, if we're deciding this on stipulated facts or if we have some facts and controversy. Okay,
Yes. Thank you.
is there anything else the two attorneys would like to talk about while we're here?
That was 1:30 on the 12th.
Yeah. And I assume we'll do that by Zoom again because I don't think we'll have our vaccines yet. Well, some of us may, but not me.
Diane, I just want to be clear, that doesn't affect the February 12th discovery cutoff date, nor does it affect that they're going to start setting up depositions in case we don't get it all by stipulated.
Right.
Correct.
Correct.
So
Thank
what
you.
we're going to do on the 12th is simply know which direction we're going and set dates for the hearing at that time.
Exactly.
Okay.
I would like to go ahead and have a witness and exhibit list exchange date.
Okay. What do you propose for that?
January 3 or 4 or 5. How about 5?
Third's a Monday.
January 5th?
Yep.
So that's the deadline to exchange witness and exhibit lists and give a summary of what they're expected to testify about.
Right.
Okay.
As long as that's a preliminary and not final list, I'm fine with that. I mean, before we dig into discovery, I don't know quite everything we'll have, but it seems fine. It's a preliminary
Yeah.
list.
I agree. All right, anything else?
Michelle,
Diane,
do
would you like to see, I'm sorry, go ahead, Todd.
you want a deadline for requesting subpoenas?
That would be nice. Well, we can do that next time because then we'll know when the hearing is and everything. The only thing I would like to see if maybe Diane would like to ask if one of council would like to prepare the pre-hearing order or the pre-hearing order from today.
I'd be glad to.
Well, thank you, Todd, for volunteering to prepare order. You can tell that I'm not used to sitting in the seat of a judge, but thankfully we have Judge Hendricks here.
And Michelle, that way we can get Todd to do that pre-trial order.
Yeah.
I will circulate that promptly.
All right.
Thank you, Todd.
Well, I appreciate everyone being here. If there's nothing else, I think we can call this hearing to a conclusion. And I'll see everybody again who can be here on January 12th at 1:30.
Stay healthy, everybody.
Be safe.
Thank you.
Stay healthy.
Thanks.
Thank you.
Get better, Alan.